Welcome, everybody. Thank you very much for joining. I'm Erin Daly. I'm the director of the Global Network for Human Rights in the Environment, which is a network of scholars, activists, and lawyers from around the world whose work lies at the intersection of human rights and environmental protection. So I'm delighted to welcome you to the second in our series of webinars examining human rights strategies in climate litigation. Before we begin, I just want to thank our wonderful panelists for lending their expertise and experience to this rich conversation. And of course, a great thanks goes out to everybody in the audience, to you for your patience in this, and also for those who will be watching the recording. We certainly hope that you enjoy the program. We also want to give a great big thanks to Dave Valet and Barbara Mendel of Widener University Delaware Law School for their generous support of our work. Our first webinar in early June featured experts from around the world providing an overview of new trends in climate change litigation in a global context. The recording of that webinar is now available on our website at gnhre.org. Today, we're very excited to formally launch our world tour, beginning with a South Asian perspective. Just to preview what's coming up ahead, next month at the beginning of August, we will visit Latin America to learn about emerging trends there with a stellar ensemble including activists, lawyers, and a member of the Inter-American Commission for Human Rights. In September, we'll turn to Europe, and thereafter we'll visit other regions of the world. For now, we turn to India, where Dr. Uday Shankar, GNHRE's Regional Director for Asia, has assembled an all-star panel. Dr. Shankar, who will be joining us shortly, I'm sure, is Associate Professor of the Rajiv Gandhi School of Intellectual Property Law at the Indian Institute of Technology in Kharagpur, India. So let me just briefly introduce our speakers for today. You have information about them on the website, but just to give you a little bit of background about them, Surya Deva is Associate Professor of the School of Law at City University in Hong Kong and a member of the UN Working Group on Business and Human Rights. His primary research interests lie in business and human rights, India-China constitutional law, and sustainable development. He is one of the founding editors-in-chief of the Business and Human Rights Journal and sits on the editorial advisory board of the Netherlands Quarterly of Human Rights, the Vienna Journal on International Constitutional Law, the Indian Law Review, and the Australian Journal of Human Rights. He is also an elected member of the Executive Committee of the International Association of Constitutional Law. Next speaker, Mr. Sanjay Upadhyaya, is an advocate of the Supreme Court of India and the founder and managing partner of India's first environmental law firm, Enviro Legal Defense. He has been practicing environmental and development law since 1993. He was a visiting fellow at Bolt Hall, a School of Law at the University of California, and a legal intern to the Earth Justice Legal Defense Fund, a global fellow in marine policy at Duke University. He has served as environmental and development law expert to a number of international, multinational, and state institutions. He has served on drafting committees of several laws related to environmental law. And last, Professor Tara Prasad Sapkota holds a PhD in environmental law from Nagoya University in Japan and an LLM degree in international law also from Nagoya University, and a master's degree in political science from Tribhuvan University. He is also research fellow at Bergen University in Norway. Currently, he is senior advocate to the Supreme Court of Nepal, a member of the IUCN-WCEL, and a member of IUCN Academy of Environmental Law. Also a member of the Access to Justice Commission for the Supreme Court of Nepal, and a member of the Tribhuvan University Center Environmental Law in the Faculty of Law of Nepal. So if we can now begin, and I'll turn the floor over to Professor Surya Deva. Thank you.
Thank you very much, Erin, and hello everyone, and apologies for the delay, and it's unfortunate that Uday is not here, but I will start. So thank you once again for the invitation. I will begin with providing a brief context because I would like to see why climate litigation in South Asia has not picked, despite South Asia being quite rich jurisprudence on environmental litigation. And I would like to mention both procedural aspects and the substantive aspects that have facilitated this rich jurisprudence in South Asia on environmental litigation. When it comes to the procedure, the judiciary in South Asia, several countries, not just in India, have developed public interest litigation. They can also admit cases on their own, suo motu jurisprudence. They have the power to invite amicus to assist them. Class action is possible, and the courts can appoint local commissioners to monitor, to provide progress on these cases. At the same time, the courts have also started having the continuous mandamus, and that's why this creeping continuous jurisdiction allows them not only to dispose of a case once, but continue to monitor what the governments or the companies are doing in relation to a particular matter. In terms of the substance, the courts have interpreted human rights or fundamental rights in the Constitution, most prominently right to life, very broadly. And that has allowed a significant number of environmental law cases. The courts have also developed precautionary principle, polluter pays principle, and last but not least, they have developed the principle of absolute liability in certain cases. Otherwise, strict liability is also there. So because of these procedural and substantive flexibility and innovation, the environmental litigation in South Asia has bloomed for several decades now. And I think it is one of the leading regions in the world when it comes to the environmental litigation. But if we start looking at climate litigation cases in some of the jurisdictions, and I try to look for India and Pakistan as my case studies, I could only find very handful of cases, and my panelists may correct me if I could not perhaps discover all the relevant cases. And then I started looking at what could it be? What are the differences? And perhaps there are several differences between environmental litigation and the climate change litigation. And perhaps because of these differences, there are not enough cases yet. The first, I would like to point very quickly 5 differences. First is the affected communities. In environmental pollution cases, it is much easier to identify the plaintiffs who are suffering because of the water pollution, the noise pollution, air pollution. At least some plaintiffs could be identified, if not everyone. But I think in climate change cases, it may not be as simple to identify people who have suffered harm directly. The second element is the causation. In environmental cases, perhaps it is easier to establish a causal connection between what the government department or a company did or did not do. But in case of climate change, there are a number of actors causing negative impact on the climate. And that's why it is very difficult to build a precise causal connection. The third element is the share of contribution, because there are millions of actors which are contributing to adverse impact on climate. Then what is the share of which actor? This is again a difficult question to determine in many of these cases. The fourth difficulty I see is the transnational dimension. Many of these environmental cases that have been litigated in South Asia, they relate to the entity or the activity taking place mostly within the jurisdiction, territorial jurisdiction of that country. But climate change litigation need not be that. My fifth and the last point of difference is remedies. It is easier to articulate remedies in the context of environmental litigation as compared to climate change. Because climate change, what are you asking? You're not merely asking for compensation. You're asking something more than that in many cases. And what could it be? And even if it is compensation, how much should a government department or the company do in those particular situations? So perhaps because of these number of differences and factors, it is possible that the climate litigation in South Asia has not yet started to pick. But still there are some cases, and I would like to discuss 3 cases, 2 from India and 1 from Pakistan, as an example of these early climate litigation cases. The first case that I would like to mention is a suo motu case admitted by the National Green Tribunal in 2014. This is a case about the state of Himachal Pradesh. And the key issue in this particular case was that the black carbon is resulting in the melting of glacier, the Rohtang Pass, and that's why the NGT, National Green Tribunal, admitted this case. And the reliance was placed on Article 21, which is right to life. But interestingly, they also invoked a directive principle of state policy, 48A, and a duty, a fundamental duty of citizens under 51A. Now, what was the outcome of this case? Interestingly, the NGT did not order the government of Himachal Pradesh that it has any obligation to reduce global warming or reduce the emission of greenhouse gases or something like this. At the same time, the tribunal issued a number of recommendations in terms of what the government should do. For instance, the tribunal directed that CNG buses and electric buses should be bought and they should be run. They also talked about that the crops should not be burnt because burning of crops is leading to this black carbon. And they also directed the government to plant more trees, reforestation efforts. That is the first case which I briefly wanted to mention. The second case, again, a National Green Tribunal case in India is Pandey. So Pandey is a 9-year-old child from the state of Uttarakhand, and he filed this case in 2017. And very interestingly, in this case, this is child, and the claim is being made that the climate impact can impact the future generations much more. So children are more vulnerable, and that's why lack of action, which are science-based, and on the part of the government, there's not enough being done to reduce the negative impact on climate change. Number of things were pleaded in this particular case. Environmental laws were invoked. A reference was made to sustainable development. Paris Agreement was referred that because India had signed the agreement, that's why it has obligations. A reference was made to precautionary principle and public trust doctrine. So you can see, in way of contrast, the first case, the state of Himachal Pradesh case, the sole reliance was on fundamental rights provisions or the provisions or directive principles of state policy and the fundamental duty. But in this case, a huge number of subsidiary principles or the wider principles were engaged to make a claim. Interestingly, the plaintiff wanted the government to prepare a carbon budget. The plaintiff wanted that the climate consideration should be part of the environmental impact assessment, and that the project which are approved by the government, they should consider these factors. Now, I would like to highlight two recommendations or two things which the tribunal highlighted. One, in my view, is a positive, and the second is not so positive. Let me start with the positive recommendation of the tribunal. The positive recommendation was that the tribunal observed that climate change is certainly a matter covered in the process of impact assessment. This is quite significant because if we say that the climate impact has to be considered by the government or the private sector as part of conducting environmental impact assessment, then I think that could really open a floodgate of litigation in future. I foresee that because one can plead that this was not done properly. On the other hand, on the regressive side, I will argue that the tribunal said that there is no reason to presume that the Paris Agreement is not reflected in the government policies or the environmental clearances of the projects. So rather than trying to assess and investigate whether the government policies have taken into account the Paris Agreement, the tribunal is assuming it and affirming it, that there is nothing to dispute it. And that's why we're not going to do anything about it. And I find it very odd, the National Green Tribunal saying it. Now, the third and the final case that I would like to pick from Pakistan is the Lageri case, which was filed by a farmer. Again, very interesting, the farmer filing a case of climate change in Pakistan in 2015 before the Lahore High Court. And again, the key issue in this case was that the non-implementation of the national climate change policy in Pakistan is resulting in the violation of my right to life under Article 9 of the Constitution of Pakistan. And I think I would say that this decision of the Lahore High Court, and there have been a series of decisions because the court continued to monitor it, is quite remarkable that they have issued quite far-reaching observations. For instance, the court is saying that we need to move from the environmental justice dimension to more holistic climate justice dimension. So don't merely stop at environmental justice, but we need to broaden it to include other elements of it. Then they requested all the government ministries to appoint a focal person which will liaise with the climate justice ministry, not climate justice, climate change ministry in Pakistan. That is the first order that they made. They also constituted a 26-member climate change commission to implement the national climate change policy as well as the climate framework in Pakistan. And that commission again came up with some recommendations. And after those recommendations were accepted, the commission was dissolved, but a standing committee was established, which was going to work as a liaison between the judiciary court and the executive in Pakistan. So the court continues to monitor what the executive is doing in terms of the climate change framework and the recommendations. The court also requested the government to provide adaptation points to implement the climate change framework. So I think because of these factors, I felt that this is quite relevant. Now let me move on to the final part of my submission, and that is reflecting about the future of climate litigation in South Asia. And I will make 6 points. My first point is that I hope and I expect more cases to come in future in South Asia for a number of regions, and I will mention those quickly. And I also expect that these cases will also be filed against companies, the private sector, because so far the cases that I have found, even if they're handful cases, all these cases that I found are against the government, the state government or the central government. And it was surprising for me that there is no case, at least I could not find it, maybe perhaps there are, not against the private sector, which I think could be because of the challenges that I highlighted before. Second, I felt that even if those cases have been filed, climate change in the submission, in the plaint submitted, or in the reasoning of the court or the tribunal is sometimes at the periphery. It's not the center stone of the litigation. So the analysis on climate change is very little and tiny. It's not very sophisticated and rich jurisprudence, unlike the environmental litigation. And I think, again, this should change, and I hope that will change in the future. The third is, I would like to see more and more reliance on human rights. So far, I have seen reliance on right to life. But climate change impacts virtually each and every human right, including right to food, right to health. It has implications for right to information. It could have implications for freedom of speech and expression, right to assemble, to protest against these policies or the projects which could inform climate change, negative impact on the climate change. And that's why a range of human rights should be relied on going forward for this litigation. My fourth point is that climate consideration should be seen more integral to environmental impact assessment as well as human rights due diligence. Now, human rights due diligence is a relatively new concept in the field of business and human rights, very well established because of the UN guiding principles. And businesses, all businesses are expected to do this due diligence for their activities on an ongoing basis. And if climate change is part of this due diligence, I think this is likely to trigger some litigation. And in fact, a concrete example from Europe is the cases being filed in France against some big companies because they have not done adequate due diligence. My second last point is that we should not look at merely courts, but we should also look at non-judicial mechanisms, let us say national human rights institutions, as a potential option to seek remedies. And here, it's not part of South Asia, but the Philippines Human Rights Commission has really set a biggest trend. But we can also look at national contact points under the OECD guidelines against multinational enterprises. That could be an option, especially if it is a company from an OECD country operating in South Asia. Then you can complain, not in South Asia, but to the NCP of that country from where that company is coming from. My last point is that we should look at the differentiated impact of climate change on different rights holders. I mentioned to you that in one case, the case was filed by a child. So going forward, I would like to see indigenous people, women, children, because all of them are not impacted by the climate change in the same way. And that's why this differentiated and perhaps disproportionate impact on some people should be part of the argumentation going forward. Thank you very much. I will stop here.
Thank you. That was fantastic. And we really appreciated not just that wonderful sort of regional overview from cases from India and Pakistan, but also some very clear recommendations about ways to further integrate human rights strategies into climate change litigation. So we're very happy to get that intervention. Thank you so much. Our next speaker will be Sanjay Upadhyaya. So Sanjay.
Thank you, Erin, and for introducing us. Thank you, the entire team of Global Network for Human Rights and Environment. And you know, in Hindi, when Surya Deva speaks, you know, when the sun god speaks, then there's very little left for others to speak. So I'm going to still try and do some justice after what Surya has spoken so eloquently. So, okay, I'll be quick. You know, good lawyers speak less outside courtrooms, they say. So I'm going to be very brief. But because a lot of things have already been said by Surya on a serious note. When Uday told me to speak about climate litigation and the human rights approach, I think what's important is to understand both these contexts first. The climate litigation environment that India has, which is rather poor, as already pointed out. And then, of course, whether we are using the human rights approach to understand litigation on climate change. And what we've seen is that there's a mixed bag of both these in the climate litigation, the few that we have. Largely, the bigger point I wanted to make was, if you look at climate litigation, something that you need to understand very carefully is what is climate liability. And I think unless we understand the climate liability discourse in India, there'll be little progress as already been made out. And I think the normal posturing that we do, and I'm using the word very carefully, is about principle of common but differentiated responsibility. And that's and I agree with that. It's not that I disagree, but there's a reality on ground, and there is a posturing in the international arena. And largely, we have been saying that the developed nation should bear the cost of, you know, the GHG reduction, etc. And compensation is perhaps the way forward. But the trick is, and the difficult part is, how do we fix that liability? How do we quantify that compensation when you're talking about climate liability in a climate litigation framework? And what we have said, and there are instruments in India where that you can think through in terms of developing that frame for environmental justice and for climate litigation to be compensation based. One or two tools that we see, for example, the RED Plus, which flows out of the climate negotiations and the UNFCCC, is something that we are still grappling with in India in terms of the forestry aspects. So if you save a forest, then what kind of compensation regime can be worked out? And that is something that we are still grappling with. The other difficulty, unlike some countries, is that we don't yet have a legislation. There is no legislation which fixes government responsibility, so to speak, when you talk about paying compensation for climate change or as a result of promoting unsustainable industries in the environment. So I think, or those cases which affect vulnerable communities, we still don't have a legal framework that we can sort of go back to. We are still trying to take strength from different instruments, and I'll just come to that very quickly. But before that, I think it's important that this whole international posturing that we have and the reality on the ground, I think we really need to take it head on as we speak. There are enough evidence out there to suggest that we haven't been doing very well from the environmental standpoint. you see the changing weather patterns, or the flash floods, or the heat waves, and the coastal storms. And I think the agricultural produce, we have done enough damage, and I think there is enough evidence to that. There's also the manner in which we are trying to grow. India has this famous ease of business approach nowadays. Uh, so we are really taking the environment on a back seat. And if it is so obvious, then obviously we need to have a very robust framework, the legal framework, when you talk about such rapid changes and how do you address that. And if the governments don't do well, or if the industries don't do well, then what are the mechanisms to really take them on in terms of climate change? Uh, in India, what I would say is that we've had a very soft approach, if you like. We have the National Action Plan for Climate Change, for example. We have about 8 missions that we have, each of them giving a priority, whether it's the solar mission or the energy efficiency mission or the Green India mission. There are many such, for the Himalayan region, we have a mission. So we have several missions, but unfortunately, it is not justiciable. These are not instruments that can be taken to courts, and they are largely policy instruments. So that is one drawback. So what are the legal possibilities? Should it be a right-based approach, where we largely use what we call as Article 21 of our Indian Constitution, which is right to life and personal liberty? Should it be a human rights approach to create potential litigation for those who are impacted by climate? And I think these are things which are still evolving in India. But I think it's important to have a robust framework itself, a legal framework on ensuring that if there are climate impacted people, then they need to be looked into. And when it comes to locus, for example, I think Indian judiciary has been fairly progressive in terms of locus. And anybody, as Suryadeva mentioned, that even a small girl like Riddhima Pandey can shake up the National Green Tribunal on a climate litigation. And locus normally is not a very big hindrance, unlike many countries I know, including the West, where locus is a very, very important issue to grapple with. Even our constitution, if you look at the provisions already mentioned, we have an Article 48A, which talks about the state's responsibility in protection and improvement of environment and safeguarding the interest of environment. So we have, although these are called what is called as directive principles of state policy, which is very aspirational and not justiciable, but still there have been many cases where these directive principles of state policy have been used for litigation, environmental litigation, including some of the climate litigation that we have. There are many other approaches or anchors, if you like, that we could use for climate litigation through a human rights approach. Whether it's the institutional failure that we can talk about, the policies that we have. For example, we have the National Environmental Policy, which we can use for litigation. We could also use, as I said, the human rights framework, including the rights of the climate impacted people, and weave that into what is called as the Article 21 within the Constitution. And in that sense, our judiciary has been fairly broad and very responsive, I would say. I don't think very many judiciary can be so proud of talking about so many doctrines that we have evolved, trying to expand our Article 21, which is right to life and personal liberty, as I mentioned earlier. And one of the important principles that we have evolved is called the public trust doctrine. And this has been used, in my understanding, the maximum in most environmental litigation, and perhaps can be used a lot in climate litigation as well. Similarly, we have the precautionary principle, the polluter pays principle, and the sustainable development principle. In fact, these three principles are now one of the bedrocks of the National Green Tribunal itself. If you look at the National Green Tribunal Act, for example, there's a specific section which actually says that any decision on environment has to take into account these three cardinal principles of environmental law, which is now part of right to life as far as the Indian jurisprudence is concerned, Indian environmental jurisprudence is concerned. So I think we have a number of these doctrines that we can very creatively use in climate litigation. And for those who needed these case laws, I saw some chats. This presentation will be available. So you need to make your notes. You'll get all this for whatever it's worth. Uh, Another important point that I've seen, we are now seeing in India, which is not so publicized, is the use of the non-regressive principle. Now, this is something that I love talking about, that any environmental dispute or any environmental changes in terms of policy or executive instructions or legislation that are coming in India today, largely because of this whole economic growth that we want to see, cannot be regressive in nature. And we've tried to argue some of these cases where we wanted to make non-regressive principle as a cardinal principle of environmental law. And we've been slightly successful in getting it through one of the important cases in NGT called the Spen Bio case. For those who are interested, I'll share the first title and other references. I'm not going to talk about Ridhima Pandey, that has already been mentioned. But what is important again by some of the high courts is that now there is also a trend where the natural resources are being termed as living entities. For example, Justice Rajiv Sharma in the Uttarakhand in northern India had said that rivers will be a living entity. For some reason, the Supreme Court thought it was going a little beyond the jurisprudence, and they have stayed that particular judgment. But he has not stopped. He's gone and created and said that glaciers and forests and rivers and lakes, they're all living entities, and you need to be looking at them as living entities. So I think these are good signs for climate litigation, because once you have the jurisprudence evolved to such a level, then obviously it's going to help any climate litigant in the future. And I think there are other cases also in terms of looking at the National Action Plan for Climate Change to become a reality, which is very similar to what Leghari case did. And my dear friend Syed Mansoor Ali Shah judgment is fairly well spoken about. He's now in the Supreme Court, so I'm hoping that some more judgments come of that nature. And sometimes, it's always very individual driven. And I'm sure people from South Asia will relate to this, because we had most of these environmental climate litigation during the previous regime of Justice Swatantra Kumar. But somehow in the next leadership, we haven't seen very many litigations. So sometimes it's not just about well-researched cases, Surya, because you mentioned that sometimes these are not well-researched. I have had some personal experiences of doing some very well-researched cases on carbon emissions, etc. But we were thrown out of court by saying that these cases are matters of policy, and NGT is a regulatory body, an oversight body. It will not get into policy matters, and therefore I need to go to the government. So I think there are well-researched cases as well, but sometimes it's also about who's manning or who's steering a particular institution that matters. My last slide is a slide of hope, because I think if you look at the legislative framework in India, the climate law exists. And we can draw out from different, not just the legislative instruments, but also the case laws that we have. And human rights perspective is largely written on it. It's a central factor in climate litigation. The executive instructions, the policy mandate, again, is fairly certain. The judicial intent is clear. I think the seeds of climate justice, if you want to call it, is already sown in India. The scientific understanding exists. I mean, we've been heading the IPCC panel through Dr. Pachori, unfortunately no more. Also, so there is scientific rigor, and solutions do exist. So I think it's only a matter of intent. It's only a matter of foregoing the posturing. It's only a matter of meeting the bull by the horn, if you like, and ensuring climate justice within. And I think we can do it. It's only a matter of time that we'll lead by example in South Asia. Thank you so much for your patient hearing.
Thank you very much. That was extraordinary. So for those of you in the audience, again, we apologize for the slight delay in getting started, but as you can see, the wait was well worth it. That was another extraordinary presentation. I'm also delighted to say that Uday Shankar has gotten on. We just had some technical difficulties, so we're very glad that he's here. Now that he's here, let me just reintroduce him. He is, as I mentioned before, the GNHRE's Regional Director for Asia, and he is the one who's sort of responsible for collecting this all-star cast of panelists that we're hearing today. Dr. Shankar is also Associate Professor at the Rajiv Gandhi School of Intellectual Property Law at the Indian Institute of Technology in Kharagpur, India. So we'll go on to our third speaker now, to Tara, and then we'll hear from Uday. So Tara, the floor is yours.
Okay, thank you. Thank you very much, Irina, for your nice moderating. And everyone, good evening to all distinguished speakers. Today, I would like to focus on the Nepal's framework studies for climate change. So Nepal has contributed to only 0.027% of global greenhouse emission, but she is the fourth most vulnerable country in the world due to the effects of climate change and due to increasing temperature and change in precipitation patterns in different sectors, including agriculture, forest, water, resources, and disasters. Nepal is serious to address climate change issue. Therefore, Nepal has made several commitments at the international and regional level as well. Nepal has become party to the following international conventions and regional conventions. At the international level, the UNFCCC 1992 and the Kyoto Protocol and the Paris Agreement and the Sendai Framework and Sustainable Development Goals and the Vienna Convention on ozone layer depletion 1985 and London Amendment, and also London, yes, these are the instruments that are relevant to the climate change issues. Nepal has become party to these. At the regional level, there are two instruments. Basically, instead of instrument, these are the declaration of the SARC. The first declaration was held in Dhaka on July 3, 2008, and that was the Environment Minister's Dhaka Declaration on Climate Change. That declaration agreed for adaptation of climate change to protect the lives and livelihoods of people for food, water, and energy securities. And the second one was Thimphu Statement on Climate Change, which was held on 29 April 2010, which was agreed to establish an intergovernmental expert group on climate change to develop clear policy, direction, and guidance for regional cooperation and establish institutional linkage among national institutions for climate change issues. These are the two instruments at the regional level. Nepal has adopted the regional as well as global environmental instruments requires to develop policy, legislation, and to create or establish institutions or strengthen the existing institutions in order to implement the global instruments as well as regional declarations. Taking into consideration of those of these global as well as regional instruments, Nepal has adopted several policies, strategies, action plans, and periodic plans, as well as laws and institutions. There are so many. Yes, I would like to give the name here. First, the National Environmental Policy 2019. This policy aims to prevent, minimize air, water, soil, noise, electromagnetic wave, radiation management, waste, development, expansion of greenery, integrate all development concerns to mainstreaming development, to ensure environmental justice to pollution victims, to involve people in environmental protection, sustainable development, natural resources, utilization of natural resources to be justified between present and future generations. And also conduct research in environment, utilization of land as per the land use planning, and the reuse and recycle of sources as much as possible. These are the aims laid down by National Environmental Policy 2019. The second is National Climate Change Policy. This is also 2019. Before this, there was National Climate Change Policy 2011. During that period, the state was in constitutional monarchy, and now the country is in federal republic structure, and taking into consideration the federal central government or federal government and state government and local governments. There is three tiers of governments in order to make responsible all the governments at three levels or three tiers, and the climate change policy has been reformulated or reframed, and also address the latest developments the Nepal has committed, signed to or obliged to fulfill the commitments of global instruments. The National Climate Change Policy also aims to improve sustainable and environment-friendly development, promotion of renewable energy, like that. There are so many 11 objectives of this climate change policy. And now I would like to highlight some other policies. The National Forest Policy. There was also National Forest Policy in 2000, and the National Forest Policy also reformulated in 2019, and this policy is also more moderate and also aims to address the climate change issues, as well as how to make the forest, how to increase the forest coverage, as well as how to utilize the forest resources. These are the major things, and also at the same time, the by protecting the forest, conserving the forest, we can sink the carbon dioxide, and as well as we can also sell the carbon to other countries by producing green forest. The National Adaptation Program of Action Plan. We have also, thus I already mentioned the National Climate Change Policy 2011. On the basis of that 11, the National Adaptation Plan of Action (NAPA) was developed in 2010. Before the climate change policy, and the NAPA is the first comprehensive government response to climate change, which identified 9 urgent and immediate climate change adaptation priority programs related to 6 thematic sectors. And the next one is the Climate Resilient Planning Tool 2011 was formulated by National Planning Commission, which provided a climate resilient framework to guide the country in implementing development plans. And the next one is the Global Adaptation Plan of Action, LAPA, which was adopted in 2011. The LAPA 2011 provided operational instrument to implement the NAPA, which prioritize adaptation actions. LAPA aims to integrate climate adaptation activities into local and national development planning processes. Another one is the National RED Plus Strategy 2018. The strategy aims to reduce carbon emission, enhance carbon stocks, and ecosystem resilience through mitigation and adaptation approaches by minimizing the causes and effects of the drivers of deforestation, forest degradation, etc., etc. And we have another the National Conservation Strategy. This is the oldest or first document that outlines the conservation concept as well as conservation strategies in Nepal. Was adopted in 1998, and the objective is to ensure the sustainable use of land and renewable resources, preserve the biological diversity, and maintain essential ecosystem are the major aims of this National Conservation Strategy 1998. In 2002, the government of Nepal adopted the National Biodiversity Strategy, which sets objectives for the protection of biological diversity in Nepal and identifies government policy on its natural resources and their diversity. This strategy highlights climate-related risks such as flooding, environmental degradation and pollution, and soil erosion as the root causes of threats to biodiversity conservation. Another instrument is the Sustainable Development Goals 2015 to 2030, which commits urgent action to combat climate change and its impacts through strengthening resilience and adaptive capacity to climate-related hazards and natural disasters. It integrates climate change measures into national policies, strategies, and plannings. Another one is National Forest Policy 2015. The Forest Policy 2015 has taken a strategy for reduction of negative impact of climate change and adoption strategies. This is we had also National Forest Policy earlier in 2000, but this has reformulated and accommodated all the new developments and obligations in order to implement the obligation created by global as well as regional instruments. The forestry sector strategy we have 2016 and to 2025, which identifies climate change mitigation and resilience as one of the 8 strategic pillars. And we have another, the National Ramsar Strategy and Action Plan, Nepal, also aims to engage federal, state, and local stakeholders and capacitate them for the wetlands and Ramsar sites conservation. We have another National Adaptation Plans, NAPS, 2015. The NAPS aims to reduce vulnerability to the impacts of climate change by building resilience, adaptive capacity and resilience, and integrate of climate change adaptation into existing policies, plans, and programs. And we have also periodic plans since 1962, but the periodic plans since 1997 to date address environmental conservation policies and the programs. And the 2021, the 15th plan, periodic plan, have addressed the climate change adaptation issues directly or indirectly. If we talk about the legislative measures, we do not have a separate climate change act, but there are many legislation that directly or indirectly address the climate change issues in Nepal. The first and foremost is the Constitution of Nepal 2015, which is the federal constitution. The constitution provides environmental rights as a fundamental right in Article 30. And in Article 31, subclause 1 states that each person shall have the right to live in a healthy and clean environment. And Article 30 subclause 2 says the article guaranteed to obtain compensation in accordance with law for any injury caused from environmental pollution or degradation. It means the compensation, right to compensation has also already made fundamental rights under this constitution. Besides that, the Constitution also mandated different responsibilities to different levels of governments, central government or federal, state government, and local governments as well. And the conservation of forest resources as well as natural resources is divided from federal government to local governments. Thus, the responsibility for the conservation of natural resources as well as address the climate change issues is provided or is given to all governments. Next, the most important is Environment Protection Act 2019. Last year, before that we had Environment Protection Act 1996 or 97, and this is also reenacted, overhaul, taking into consideration of the international obligation made so far since 1997 to date. The Act and the rules has made provisions of strategic impact assessment, SIA, and environmental impact assessment before starting development activities. It also requires to make environmental audit of the project every year. These are the new things, new provisions. These were not in the previous Act. This looks like, and there is also, in addition, there is also a separate chapter on climate change. And this chapter also provides provisions for the compensation as well as to the victims of the climate change as well, and the environmental pollution. Another act is the Forest Act 2019. We had the previous act in 1993. The Forest Act 1993 aims to manage forest process resources, but this Forest Act is more progressive, and it has also provided some provisions for the not for the conservation of forest resources as well as the climate change issues. If we protect the forests that contribute to sink the climate carbons, that is beneficial for the country as well as people at large. And the Forest Act prohibits to cut trees except in the case of national pride projects. If there is a national pride project, if that requires to cut down some trees, that is okay. Otherwise, the cut down green trees is prohibited by this act. We have another act, that is Water Resources Act 1992. This act has emphasized to minimize adverse impacts on environment by way of soil erosion, floods, and landslides or similar other causes. And it has also introduced the community and users groups concept. The watersheds are provided to the community, and the users groups, they are responsible to conserve the watersheds. We have Local Governance Operation Act 2017. Before that, we have local Development Act we had, and now it has replaced that Local Development Act, and now the Local Government Operation Act 2017 recognizes that local people and the local bodies are the most appropriate points to meet the climate change adaptation needs at the local level. It also authorizes to undertake carbon reduction and environment-friendly development with respect to climate change by local bodies. Yes, we have another Disaster Risk Reduction and Management Act 2017. The Disaster Risk Reduction and Management Act promulgated in 2017 has categorized the disaster for the first time into two groups, natural and human induced. It defines the climate change related disaster as natural disaster. It provides detailed action plan for different levels of government to execute the disaster management plan. If we look at the institutional measures, we have lots of institutions of these, the National Planning Commission of Nepal, which is responsible for the formulation of periodic plans as well as sectoral policies, and it has also developed so many policies and strategies for the related to the conservation of water resources, forest resources as well. And we have also Climate Change Council, the highest body. The National Planning Commission is also highest body, and the Climate Change Council, which it was established in 2009 by a cabinet meeting. The Climate Change Council is a 25-member high-level coordination body chaired by the Prime Minister, and includes 11 ministers and 8 technical experts nominated by the government, with Ministry of Forest and Environment, and functioning as the Ministry of Forest and Environment is functioning as the Secretariat of the Council. The task of Climate Change Council is to provide high-level policy and strategic vision to coordinate financial and technical support to climate change-related programs and projects. Yes, we have another institution, that is National Climate Change and Knowledge Management Center. This is based in NAST, and with the mission to serve as a dedicated institutional arrangements for managing climate change knowledge in Nepal, and the goal of providing a platform for coordinating and facilitating the regular generations, management, exchange, and dissemination of climate-related knowledge and capacity development services to a multi-stakeholder climate change community of practices in Nepal. Yes, likewise, Red Shell. We have also Red Shell, that is Implementation Center, were established in 2014. Focal persons for climate change. This is the Red Shell, is the focal person for climate change in different ministries. And we have several ministry. Ministry of Forest and Environment is also responsible for the conservation of forest, for the conservation of environment, protection of environment, as well as climate change, management of climate change and adaptations. The Ministry of Forest and Environment has adopted the Forest Policy 2015, the National Adaptation Plans 2015, Climate Change Management Division we have there, and the Ministry of Energy, Water Resources and Irrigation is also another important ministry that is responsible for the conservation of natural resources like water, as well as conservation of forest, and it has adopted National Water Resources Strategy in 22, and National Water Plan in 2005, and the 3-year interim plan has devoted a separate chapter on natural disaster management in its planning document. And the irrigation policy, we have also Irrigation Policy 2014, which aims to provide irrigation facility round the year for the achievement of the objectives related to the climate change through effective management of existing water resources and strengthening institutional capacity. Yes, the Ministry of Water Resources, Energy and Water Resources has also developed the Water-Induced Disaster Management Policy 2015, recognizes climate change as one of the causes for water-induced disaster. It also focuses on disaster prevention programs to make them climate resilient and environment friendly. Another ministry, the Ministry of Agriculture, Land Management and Cooperatives. It has adopted National Agriculture Policy 2004, which emphasizes on conserving, promoting and utilizing natural resources, environment, and biodiversity. And another policy, it has adopted the Climate Change Adaptation and Disaster Risk Management in Agriculture, Priority Framework for Action 2011 to 2020. Also, important strategy for the management of climate change, as well as climate adaptation and climate risk management. The national land use policy 2015 was also adopted by this ministry, and the agriculture ministry also adopted the agriculture development strategy 2015-2035, which targets to increase the volume of food production through higher productivity and sustainable use of natural resources. It focuses on improved preparedness and a response to emergencies and climate smart agriculture practices. The Ministry of Home Affairs is responsible for risk management. The ministry has adopted the National Strategy for Disaster Risk Management 2009, which recognize that climate change is a serious risk, and climate risk management and adaptation to climate variability were taken as significant priorities in this national strategy for disaster risk management. Let's see the judicial responses. The judiciary in Nepal is always proactive for the conservation, for the protection of environment. And in 25 years back, we had the Constitution of the Kingdom of Nepal 1959. In that constitution, there was no any provision, neither in fundamental rights nor in national policies or plans about the protection of environment. However, the Supreme Court in a case, Surya Prasad Sharma Dungel versus Godavari Marble Industries, the Supreme Court issued interpreted that people has right to life. The Constitution had abolished the death penalty from the Constitution. On that basis, the court interpreted that if we have abolished the death penalty from the Constitution, then we have right to life. And if we have right to life, then we have to, we need healthy and clean and healthy environment in order to enjoy right to life. That court interpreted like that way, and also order to the government to enact Environment Protection Act and regulations. In 1997, the government enacted the National Environment Protection Act, and in 1997, Environment Protection Regulation. This has a great contribution done by the court. And till date.
Excuse me for interrupting. I'm sorry. I'm just going to jump in because I want to make sure that we leave time for questions. So maybe if you want to just wrap up.
Within a minute, I will finish it.
Thank you.
And the second time, the court has delivered judgments and issued orders. So in many cases, more than we have 1 dozen landmark cases and almost 6 dozens court cases decided by the Supreme Court relating to the environmental protection. And the latest one in 2019, on December 29, 2019, the court also issued a directive order to the name of Prime Minister and Council of Ministers to enact a separate climate change act. Although the government has not enacted a separate climate change act, but the court has ordered to enact separate climate change act. And just taking into consideration, the government has inserted one chapter in Environment Protection Act 2019, one chapter regarding climate change. Many things are there, but that is not sufficient. We are still demanding to enact a new separate climate change act. Let me conclude. The measures adopted by Nepal are good compared to the other countries in third world. Just I mentioned so many policy strategies, action plans, and laws, institutions. However, there are several gaps in the policies, legislation, and institutions to address the climate change issue. Even these laws, institutions, policy studies are not perfect and adequate. We need to review again and again. The new policies, studies, and legislation are good compared to previous one, but these new policies are to be implemented in full phase. While implemented in full phase, then we can see the impacts, how these new policy studies are perfect or proper or not. We have to see the implementation aspect. However, the National Adaptation Program of Action, NAPA, which was adopted in 2010, can be a milestone in sectoral adaptation of climate change issues, largely because it has provided the national framework for sectoral adaptation to climate change. Although NAPA ignores the importance of structural.
I think we're going to have to stop there because we do really want to have time for questions.
Judiciary is always proactive, and the decision of the judiciary are not implemented effectively. This is the drawback of our system. Thank you very much for listening me.
Thank you very much. It was absolutely fascinating, and I'm sure a lot of people just weren't aware of how much is going on in Nepal, and still we have the problems of implementation that we see everywhere. Uday, let me turn it over to you. Thank you.
Let me begin with my profound apology to all the three speakers with whom I have been in touch for last fortnight or so to start this webinar on time, but because of unexpected technical glitch, I could not, join on time. I was in my office, then I rushed to my residence to join. Luckily, I made it. After listening to two speakers, I missed the deliberation by Professor Surya Deva, and hopefully I'll catch up with him in person and then try to find out what Professor Deva has, informed us about this very pressing issue, because this one issue appears to be, taking us along with the development which is happening on technological side, because there is general perception that law is always 2 steps back when you relate it with technology. But when we are talking about human rights strategies in climate change litigation, somewhere we are talking of walking together with all technological development, so that we can equip our judicial system to effectively address the challenges which the victims of climate change can bring it before the court of law. We have received certain questions, and I would like to pose it to our learned speakers. My first question is to Professor Deva. Professor Surya Deva, there's an interesting question which has come. This is, which is with regard to linking it with ICCPR, where it says that we have a comment number 36 of ICCPR, which indicates about the role of the dignity. Whether this shall be also eligible on for climate refugee. What would you say might be the role of dignity under international law in climate change litigation, including causes of action, remedies, adaptation, and mitigation? So we would like to hear the thought of Professor Surya Deva on this question. Professor Deva, please.
Okay, so I think when it comes to the refugees issue, I think this is going to become quite critical in future. And I would like to briefly mention about a decision of the Human Rights Committee decision earlier this year about a case. A complaint was that someone was trying to seek asylum in New Zealand, and the government denied the asylum for this person who was supposed to be deported to Kiribati, an island in the Pacific. And the committee concluded that the risk of deportation should be considered in this case, because if the climate is going to create a situation where this person may not be safe. So I think that is an interesting decision which should have implication in terms of the climate induced or climate related refugees in future. Of course, the issue of dignity is very fundamental to all human rights. And that is the issue I did raise during my presentation, that we should try to link with climate change litigation, not just right to life, but several other rights, because this has an impact on all human rights. And dignity is fundamental or underpinning issue for all these rights. Thank you.
Yeah, so there's another question to Mr. Sanjay Upadhyay, uh, wherein the typical argument between dignity rights and environmental rights, and generally it has been seen that whenever this kind of issues come up, the court generally looks at it between environment and development debate, and the court misses out on dignity debate. So how do you see this dignity debate uh, really bringing a kind of judicial engagement, because human rights argument has its own force in realization of the rights, and it is a well-known phenomena, and it's a well-known kind of situation which has been emerging, that greenhouse uh, effect is not only bringing the challenge to enjoyment of right to environment, but many connected rights are also getting adversely affected. So how do you see the courts really coming out of its comfort zone, I would say, and then trying to hammer out what exactly is being looked at by public at large?
So I don't know whether I understood your question correctly, but let me try and answer that. I think the first thing that we need to understand and create all and clear all our cobwebs, that there is this environment and development debate that is being seen equitably in courtrooms. I think there is out and out development and no environment debate. Although there's a lot of lip service about environment and development that should go on and on together, but most of the decisions when it comes to big ticket infrastructure projects, we always see the environment lose. So there is no environment and development debate. It's always environment versus development, and always development, so to speak, for whatever it means, wins the case in most cases, 95, 98%. But I think apart from dignity, which you mentioned, I think the crucial part is not just dignity, but identity. And I think in the Indian context and the South Asian context also, I think tribal identity, for example, becomes a very important, anchor. Because in India, when you look at the entire forest resources and the dependence on forests, the tribal communities in scheduled areas, which are, special areas of administration in India, both the 5th scheduled areas and the 6th scheduled areas in India, where tribal identity is an important aspect. And I think that is somehow missed in litigation on environment, because the kind of dependence and the kind of customary law that we have, I don't think we have really evolved in terms of jurisprudence in the environmental debate. And I think it's important to flag that, that apart from, and because that is related to dignity, which you mentioned, that identity and dignity are sort of interconnected. And unless we put the tribal communities and the vulnerable communities at the center stage of this environment and development debate, I don't think we are going to really succeed much, because the biggest impacts on climate variations are on these communities, and who are often paid a lot of lip service. And I think there's a lot to do in that regard. I don't know whether I answered your question, but these are my thoughts.
Okay, there's one more for Professor Surya Deva. This is interesting question which has been, posed, that how do you really see this the very whole argument of the international position on refugee, and how this international legal framework which has been coming forward to protect refugee is really bringing a kind of rescuer for the issue where climate is affecting people at large. So do you think that this could be one issue where this refugee convention, the 1967 protocol, can be roped in for the issue of climate, on the issue of climate change?
Thanks. I think I tried to answer that question in the earlier part, where I was saying that there could be climate change related refugees. I think in that particular context, that convention or the case law or the policy framework would have to be evolved in a way that it can take care of the climate induced refugee situations. So I think that is definitely going to become relevant in my view. And that's where I mentioned the Human Rights Committee case decided earlier this year. But there's also, if you don't mind, there's the question I see in the chat from Techly is a science-based question. I could quickly touch upon.
I was about to ask that.
I can
Yeah,
quickly
please.
touch upon that question because I've read it. Is that okay?
Yes. Yeah, please.
So technically that question about science-based decisions, that was an argument made in the Pandey case. But unfortunately, the court, the tribunal to be more precise in this particular case, did not really deal with that question. And I think that's where I would like to bring on also what Sanjay was saying earlier, the research in the litigation. I feel that the lawyers are doing better job in terms of making arguments in climate change litigation, but perhaps the tribunals and the courts are not able to grapple with those arguments. And I think that is where we need to see this. So if you merely have good lawyers, but not equally good judges to capture those fine nuances or the evolutions, then I think it doesn't work. And the other way around also doesn't work. And then it becomes very personified. So those who are brilliant judges, they will develop principles. But I think we should ideally make it more institutionalized. So we need to create more of MC Mehta and more of Sanjay Upadhyay's. And I think more of judges as well. So I think that is going to create this institution where it's not ad hoc, that if one person is the judge or one person is a lawyer, and then when that person finishes, with that also we shift the green branch or climate change branch. I think that is what we need to see in this particular context. So that opportunity was not used in the Pandey case, to cut it short. But hopefully in future that will be taken care of by some other judge, I hope.
Yeah, very aptly said. We are aware of the phenomenal work which Mr. Sanjay Upadhyay is doing for the cause of environment and climate. Maybe I'll just put a last question to our eminent speakers. Very quickly, if you can respond on how do you see the challenges of implementation in South Asian countries, Nepal, India, and Pakistan? We have heard Professor Tara Prasad in detail where he has listed out the institutional arrangements has been done. He has listed out the judicial intervention which has been done on this issue. So what are the challenges you foresee in implementation on this issue? Very quick response on this. Maybe we can start with, again, Professor Surya Devas, then we'll move to Ms. Sanjay Upadhyay.
Okay, I think implementation remains a major gap in South Asia, or I would say in many countries in the world, when it comes to environmental law or human rights law, and I think the same applies to the climate change area. I think a number of things are needed. One thing which I would like to see going forward is that climate change discussion is part of the political process. I would like to see in the part of the manifestos in the elections of the council, districts, state, and the national level. It's not part of the mainstream. And I think that is the fight we have to fight, in my view, to recover the whole idea of development. So the development, which Sanjay rightly pointed out, is always winning. But that is not the kind of development we want to win. Because the idea of sustainability, inclusiveness should be inherent in development. But that is not the case. So we're talking about development of 5%. At the cost of the 95%. And I think we need to recover and change and reconceptualize this whole idea of development. Thank you.
Yeah, maybe Mr. Sanjay Upadhyay.
Yeah, so I see three things when it comes to implementation. One is whether we have the institutions who are supposed to implement the decisions that are taken. And when I talk about a country like India, which is, I call it 29 countries in one country, because it's so huge, the number of institutions matter. The second is the capacity of those institutions, because you may have the numbers, but sometimes the capacity of that institution is a huge issue. and having been associated with a few of them, for example, the State Environment Impact Assessment Authority, etc., I've seen that there are huge capacity issues. And the third is, are people going and taking back the non-implemented decisions back to the courtrooms through the instruments of law, through execution applications, through awareness, through writings? So I think these three things, when it comes in time, is perhaps we are going to see some real implementation. Otherwise, it's going to be nicely tucked away in those beautiful decisions without any real impact on the ground.
Okay, maybe a last response from Professor Tara, and also there is a question for you that what kind of projects are classified as national pride project? So if you can club these two questions, one is what challenges you see in the implementation, and the other one is on this, what kind of projects are classified as national pride project? If you can respond on these two questions.
Okay, thank you, Uday Shankar. First of all, I would like to respond. The first question is what are the challenges? Yeah, I do agree with the views expressed by Surya Deva and Sanjay. Apart from that, I would say that there is still political will is also lacking. Political will, that is bureaucratic commitments and detailed procedures. Even laws are also not adequate, and detailed procedures, even manuals. And the major problem is funding and small institutions to implement the policies and the laws. These are the challenges in South Asian countries to implement the laws and the policies. And I would like to say to respond to the second question, the national pride projects. Yeah, the government of Nepal has categorized the projects which are above the $5 billion project are known as national pride project. Some of them are hydropower projects, some of them are airports, some of them are that's international airports, some of them are regional airports, and some of them are irrigations, and some of them are road irrigation, airports, and hydropower projects. These are the some projects. The cost of the project is above $5 billion. Then these are known as national pride project, which are very essential for game change, for the fast development of the country. The government has classified like this way. Thank you.
Okay, thank you very much. And with this, we have come to an end to this wonderful webinar. And as it has been rightly pointed out by all the speakers, that human rights strategy need not be always displayed in a courtroom setup. Perhaps it is also need of the hour to make it a kind of political debate, so that we can really see change happening on the ground, not only with the help of judges and the lawyers like Mr. Sanjay Upadhyay, but also through academia and through the compelling the political parties to make it a political agenda on which electorate should be made informed. They should be made aware that this is something which is of very, very pressing importance and it cannot be overlooked. With this concluding remark, I thank Professor Erin for stepping in and doing the job of moderator, which I was supposed to take at 6 o'clock. So with Indian time, and thank you very much. Thanks for joining. I express my profound thank to all the three speakers for agreeing to be part of this webinar. Thanks on behalf of the Global Network. Thank you all. A very good evening to all of you. Thank you.
Thank you very much.
Bye.
Namaste.
Bye.
Thank you.
Thank you, everyone.